Hello and welcome. Today we're going to discuss this very important judgment on the Sterling Group, namely Nitin and Chetan Sandesara, where the Supreme Court, in a landmark order, has ordered that upon depositing a full and final amount of 5,100 crores with the lender banks, all liabilities will stand extinguished. This amount is largely the principal amount that they had borrowed. Interest and other charges have been waived off. The banks will get back their money, and all criminal proceedings with SEBI will be withdrawn. This is a landmark and good order because sometimes, due to change in the business climate, many businesses fail, but that shouldn't lead to criminal hounding of promoters who otherwise contribute to the economy in terms of jobs, in terms of investment greatly. The panelists are experts, so they will do all the talking, but I want to welcome my three expert panelists today. Amit Nayak joins me today from the city of Mumbai. He is managing partner of Nayak and Nayak. Good to see you, Mr. Nayak. Thank you for your time.
Good evening, Tarun. Thank you for having me.
I have with me senior advocate Sanjay Jain, who has also earlier served as the additional Solicitor General of India for close to a decade. Good to see you, Mr. Jain. Appreciate your time. I have with me Advocate Arshdeep Singh Khurana, who practices on the criminal side in the city of Delhi at the Supreme Court, the High Court, and other forums. Good to see you, Arshdeep. Appreciate your time.
Good evening, Tarun. Thank you for having me.
Thank you. At the outset, I'll request Amit Nayak to give me an explainer on, why this judgment created a lot of news in the corporate circles in India, and why is this important in an economy where many times, due to unforeseen circumstances beyond the control of a promoter, businesses fail. And when they do, how they should be looked at. Over to you, Mr. Nayak.
So, Tarun, I think the most important thing is that corporate India needs to see resolutions in economic matters. And I think it's very important that today, when criminal prosecution is set into motion, of course, courses for horses and horses for courses. But the fact of the matter is that today, in a matter like this, Supreme Court has obviously allowed this, and payments have been made, and ultimately banks are satisfied and happy. So I think this is a step in the right direction, and I think it sets the tone for corporate India that, look, in matters where there have been a sectoral collapse, in matters where it is beyond promoter and there is actually no fraud, then should you not have a commercial viable solution? Now, there are some takeaways from this matter also. The manner of penal interest, the conversion rate, the NPA, etc., etc. But the fact of the matter is that today there has been a resolution. And I think it's a welcome step, Tarun. I'm sure Arshdeep and Jain Saab will agree. Because ultimately you need to go, and this took a long time. This has not happened overnight. This is a process that has been followed through years. But also I'm going to be a little critical of two or three things. And I must say with a sense of responsibility that today, let us treat people who are in India. And please understand here, the promoters are outside the country. I'm not saying anything else. But the fact of the matter is, there are people who are facing day in and day out investigation in India. Please do not treat them as criminals. Please have some respite, and please find a commercial resolution. And I think this is what we need to see. When I did the matter of Naresh Gowda, and I am saying it with a sense of responsibility, and I can say it now. And of course, he lost his wife, he had medical bail. Please see the circumstances of what happened. And matters of investigation can happen. But the question today is this fraudulent? Is this someone who has left the country? This is a case in point of time, which is why I feel that the Sandesara judgment is a welcome judgment. Kudos to the Supreme Court. Obviously, the Patiala court followed in letter and spirit what the Supreme Court did. Obviously, things are with SEBI as well. So I think, if you ask me, and of course, if you look at the details of this matter, I'll come to that a little later. But I think there's a lot also. In fact, here is a matter that a lot could have been said, should have been said, but obviously a lot has not been said. And more importantly, some allowance has been given. So that indulgence and balance must be struck. And I think that's the way I would approach it. This is really my opening comment.
Thank you for your opening comment. We have to senior advocate Sanjay Jain for his opening comment. You've seen cases from both sides, from the government angle. Now you're a defense counsel, so looking forward to your opening comment.
See, I will begin by agreeing with Mr. Nayak that it is really not necessary that every person who is a respondent or who is facing a notice or is facing an investigation by one of the prosecuting agencies or the agencies investigating different aspects need to be treated as a or with the presumption of being a criminal, because that kind of assumption really dampens the spirit of the commercial world, which is not desirable in the interest of the country. Now, coming to this judgment, although this judgment gives a usual caveat that it is passed in its own peculiar facts, nonetheless, this judgment is a guiding light for future, in particularly with regard to the approach to be adopted by the honorable courts in dealing with the resolution of such kind of disputes. The judgment, in my view, is significantly positive in the commercial world for three primary reasons. First is that after all, the criminal proceedings are quashed. If the criminal proceedings are quashed, then there will be an assumption that the settlement arrived at by the parties is a genuine settlement and not opposed to the public interest or public policy. So this understanding in the public is very important. So the judgment indirectly and very solidly conveys this aspect that it is a genuine settlement. And the genuine resolution of the dispute is very important for keeping the trust of the public, especially in these kind of matters, which by the time they are resolved have already received adverse publicity, at least for the person who is facing the music. Secondly, this is my way of looking at it on account of my tenure with the government, that every prosecution and every litigation consumes a lot of court's time and it is very expensive. So it saves the cost of prosecution of multiple proceedings at different levels. So if there is a resolution, then to that extent, the government or the system is also saving the cost of prosecuting that particular respondent. This is one aspect which may not have been attended to or given a lot of thought, but in my view, this is a very important aspect. Thirdly, it reassures the public and the business stakeholders in particular that the attachment provisions in these enactments like PMLA or Black Money Act or Fugitive Offenders Act, etc., are really intended to prevent and contain the economic loss for the country and the public money. And the primary purpose is not to remain indifferent to such situations. So idea is to contain and prevent. Idea is not to prove that somebody is a proven criminal. So this is something which is very important, that we are having these enactments to save the loss to the public exchequer and the public. The primary purpose of these criminal statutes or these provisions is not to proceed on the assumption that the business community is a crook or something. So therefore, this change in attitude is important from the side of public also, because the rhetoric suits very well when people say that these are thieves, these are this, that, but
Yes.
ultimately you have to create a balance. You have to understand these situations from everybody's perspective. Like Mr. Naik pointed out, that in this particular case, the banks had a particular amount in their mind, and that particular amount was accepted to be paid by the gentleman concerned. And once they offered to pay and they paid, then all the criminal proceedings were accepted to be quashed, and that serves as a guideline for other agencies also. So that's my opening comment.
Thank you.
Longer.
Thank you for the opening comment and setting the tone that you don't look at businessmen as thieves. They generate jobs for the country, investment. They take the risk also. all of us on the panel can't take a loan of 50,000 crore. Many of us get scared taking house loans also. So, any which ways, on a lighter vein. But I'll go to Arshdeep Singh Kharana for his opening comment.
Thank you, Tarun. Tarun, firstly, I think it's a welcome judgment, positive judgment, and a great judgment for the corporate world. And we have been seeing over the years. I'll first address what the problem is, how this judgment has come out as a solution for 2 years. The problem is being a lot of these commercial issues, economic issues, which are not necessarily criminal, are put into the domain of criminal law in our country. It's unfortunate, but it is happening. And one of the features of the judgment, if you see, that a person on a single allegation of having defaulted has to face the music at the hands of various agencies. It's not one agency. It starts from the CBI, then you have the ED. In this particular case, we saw the SFIO is there. There are issues of SEBI. There are prosecution under various enactments. So for a single allegation, I think there are 5 or 6 agencies today, which I say it comes as a bouquet of cases against the businessmen. And I think the most important aspect of the judgment is that it addresses in one go. These various prosecutions have been quashed by the Honorable Supreme Court, and I think it's a very, very welcome step. That is point number 1. Point number 2, I think all stakeholders in this judgment are happy. The accused, the government, the banks. I think there could not have been a faster resolution for the banks. In one go. Their liabilities are done away with. And if you see, it also considered aspects in the NCLT. There were some companies which were sold. Money had come in. So I think it's a wholesome judgment. It looked at everything. A great judgment for the corporate world, and it's a commendable step. And I think also from a legal perspective, from a defense counsel perspective, I think there was a lot of ambiguity we had over the years, on these issues of compromise quashings. To say, you had judgments which said, look, if there is a corruption angle, don't quash on issues of compromise. But I think this judgment has really put the things in perspective. As Mr. Jain said, though the judgment says it should not be used as a precedent, but I think it's a message right from the top. And it's a guidance for all our courts in our country to follow this. And I hope that this should be followed in the corporate world, because I think another point which Mr. Jain put very rightly is it saves a lot of time for the prosecutors, for the courts. So it's a welcome step, and I think this judgment is going to go a long way.
Point very well taken, Ashti. The judgment will go a long way in ensuring that the promoter has confidence that he will be handheld, and the government will handhold him in times of trouble. I'll go to Mr. Amit Nayak. Amit, one thing I want to ask you. A couple of years ago, one prominent promoter had held a press conference where he said that I returned 70,000 crores to the banks. But when I'm in trouble, they are hounding me out. And this is the time I should be handhold, because I will take down with me at least 70,000 employees who work for me. So it's a much larger impact than we fathom. That, putting a case on a promoter looks simple, but lakhs of families get eventually impacted. Even if you've got the promoter inside jail, what effectively happens is all those families are living a living death, because they all lose their jobs. They're not able to pay loans, because they also would have taken houses. There is a ripple impact on the economy. Do you think because of that, this judgment of Nitin and Chetan Sandesara is very important, because it saves the economy? It saves the thousands of people who work for these promoters. How would you look at it? And
Yeah, absolutely, Tarun. I would say this, that you see today listed companies, promoters have a lot of shareholder value. Please, I think Arshdeep said it really eloquently, that today there are multiple FIRs, there are multiple agencies, parallel investigations that are going on. And it's the process that is the punishment. And I think one of your colleagues had said, it's the process that's the punishment, unfortunately, which is why the families get tarnished, the directors, non-executive director. That's the problem. And therefore, today, will you in a sectoral collapse, or where circumstances which are beyond your control have to face this music? That's what I've always maintained this, Tarun, on your show, that every promoter is not a fraud. Of course, there are fraudsters and they must be treated with an iron fist. But at the same time today, this judgment, like Mr. Jain said, look, it's really the Supreme Court speaking. While it is not to be treated as a precedent, I think the messaging is very clear, like Arshdeep said. Let us now see whether in larger matters the ultimate public sector undertaking is able to find a resolution. Because please understand, there are it's the prevention of corruption, and there are bank officials involved. Now the amount here is 5,100. Now, really speaking, the manner in which this settlement was done is very, very novel, so to speak. It's not pegged to any formula. It's not pegged to any circumstance. But the fact of the matter is, the banks today are able to realize the value, and we must compliment everybody, including all the stakeholders here, that today there was a resolution. Today you need to find these resolutions in matters, because if you're not able to find these resolutions, putting somebody behind bars or their families are not going to get you anything else. And that's all that you will achieve. So yes, I think it's said that tonality is correct. I think that press conference, ultimately today, if there is an Indian promoter who's ready and willing to give you a repayment plan or a schedule of payment, must you not look at that properly? Must you not look at that in a larger resolution for public sector banks? That's what I would say. And therefore, I really welcome this. And I think if payments can be made because of this, nothing like it.
Point very well taken. In fact, I'll go to Senior Advocate Sanjay Jain on this whole point of promoters. Now, in this case, Nitin and Chetan Sandesara were not in India. In fact, the hounding by the agencies sometimes make the promoters leave the country, because they feel that if they come to India, they'll end up in jail, and then the whole company collapses. Everything around them, the whole architecture that they created over years just is over, as they'll end up in jail. Very difficult to get out after that for a couple of years. Do you think, keeping that in mind, this judgment is very, in a sense, giving a message to the industry that the government is willing to look at things in a positive way, and the banks also will handhold the promoter and say, okay, you invest in India, you continue to do your business, and if you are in trouble, we will stand with you?
See, if we see at the foundational level, wherever the Fugitive Offenders Act is invoked, ordinarily it is a position where somebody is a borrower from the bankers. Now, there is an old saying that bank is somebody who gives you an umbrella only to take it back when it starts raining. So, that being the position, the banks have to reposition themselves, and they have to be pragmatic. Their focus should not be to witch hunt somebody. Their focus should be to recover the money. And sometimes it is equally important to appreciate on the part of the management of the banker that if, according to them, something fraudulent has happened, so if they are raising one finger at somebody else, then four fingers will be directed and pointed towards their own people. So they have to cleanse their own house. They have to put it in order. So they have to be more professional and lesser subjective. So therefore, this judgment, according to me, paves way for a change in the overall understanding and the repainting the canvas. Currently, the canvas is that everybody should be painted in a single color. So the banks, because what happens, it's very easy to blame the agencies. The agencies, if the complainant happens to be a nationalized bank or a big bank, and their complainant says that, look, so much of public money has been taken away by this person who is sitting abroad, then the agencies have no other option. Otherwise, tomorrow somebody will file a PIL, and the court will say that what you are doing in the wake of such a serious allegation. So agencies being triggered is something which is a matter of law. They cannot sit silent if there is a complaint forthcoming like this. The point is that after the complaint is lodged and the investigation is taken up, what should be the approach? So on that, what has been pointed out by my two very esteemed panelists, that is Amit and Mr. Khurana, is of extreme importance. That we, as Mr. Khurana mentioned, that it's a wholesome judgment. It's a very interesting expression he used. So in this wholesome judgment, if you see the positives, and these positives is the fact that, as Mr. Naik pointed out, that we have been able to resolve something. So this resolution has been possible because the complainant agreed. So the due credit also has to be given to the banks concerned who said that, all right, this is the amount which is OTS amount for us. You pay it, and then only we will think about taking back our complaint. So this is how the resolution should be achieved.
Point very well taken. I'm taking this to Arshdeep. Now, before the court, the lawyers representing the government also said that all CBI FIRs, EDPMLA cases, SFIO prosecutions, Black Money Act cases, income tax prosecutions, fugitive economic offender proceedings, SEBI cases, everything will give you a clean slate if you pay. Effectively communicating through the promoter, do your business again, start employing people again, and create employment. Do you think this underlining that cases withdrawn? Because even in this case, I think the SEBI cases are yet to be withdrawn. Everything else has been withdrawn. Do you think it should be sort of implemented to the last word promised in order to ensure that it's a clean slate, rather than, because there are these hiccups and you know better than me why they end up happening, or some of the other objections?
100%, Tarun. I think if you look at the what's happened post the judgment, the banks have been paid, etc. But SEBI then came up and said, look, we are also investigating, inquiring, and a possible prosecution. But the court had a very clear message that if we are finishing everything, it means everything is finished.
Yes.
Whether it was before the court on that day or it was not before the court. So I think the message is absolutely clear. In one go, everything finishes. And I think the message is very clear to the corporate world that if you pay up, then there is no need for you to face a prosecution or an investigation or an inquiry in the country. I think the message is very clear. And, Tarun, I want to also emphasize on, we keep using these two very important words, public money and economic offenses. And, we see that this phrase is being used, say there's public money involved, and suddenly the overtones of the case changes. But I think if you look at it traditionally, public money concept came in cases of, say, Ponzi schemes, right?
Yes.
You had real estate builder issues, where assured return issues. You had corruption issues. So that's where traditionally the law which was developed said where public money is involved, court should be careful in, say, granting bail or quashing prosecutions or quashing cases. But over the years, I feel and it's everybody is to be blamed in the system, that public money is being used very loosely. You have now cases which we see, every case where there is a default. You see, every corporate is going to deal with public money. That's the whole nature of the business or the, in the corporate world, you take loans. Everybody takes loans, and Amit used a very interesting word. He says sectoral collapse. Right. And you have sector, like, for example, you have the war going on right now. So a lot of businesses are going to suffer.
Collapse, yes.
Right. And businesses will collapse, but it's not because a person has a dishonest intention or has a malified or a criminal intent. It's the very nature of the business. It's the circumstances. Now, suddenly when this happens, a company goes into a NPA or a non-performing asset. Banks rush to declare fraud. And that, like, it triggers it's a chain reaction. There is fraud, there is CBI, there is ED, there is SFIO, and a person doesn't know what he is facing. And the unfortunate situation is that investigations take a lot of time. So by the time, say, a charge sheet is filed, which may dilute the allegation in the FIR, or say, the agency may also find there is nothing, there may be a closure after 3 years. But the damage is done. A person may be arrested, there will be attachments. His house will be attached, his office will be attached, his industry will be attached. And by the time he has some resolution in the form of a investigative report, or he goes to court and argues on charges and gets a discharge, trial, unfortunately, in our country takes a number of years. We see that trials don't even conclude for 10 years, 20 years, but by that time, the damage is done. So I think that this judgment is a great judgment because it quashes the proceedings in one go. And I think it can't get better. 7 or 8 prosecutions finish because you see the underlying allegation is the same. Every agency looks at it slightly differently. They will look at their ingredient of the offense they are prosecuting or they're investigating. But the basic allegation is the same, that you have not paid up. You took the money and you defaulted. But they will put their own little bit of ingredients. You had a dishonest intention. Companies Act will say, oh, look, you didn't fulfill the conditions of the Companies Act. So SFIO will come in. SEBI will have its own issues. So I think the judgment, the way it quashes the proceedings in one go, I think it's just commendable.
Yes. Thanks for sharing that analysis with us. On that note, I would like to thank Amit Nayak, Managing Partner of Nayak and Nayak, Senior Advocate Sanjay Jain, Advocate Arshdeep Singh Khurana for sharing their insights on the Nitin and Chetan Sandesara case. In part 2, we will delve in detail on this issue, but appreciate that you could join us. Thank you so very much.